Forget what you secretly intended. Contract formation hinges entirely on mutual assent. This requires both a valid offer and a valid acceptance. Mutual assent is judged strictly by an objective standard. Courts focus only on the outward manifestation of intent. Secret subjective beliefs are completely irrelevant to contract formation. The reasonable person standard determines whether a party intended to be bound. Preliminary negotiations or invitations to deal are never offers. An offer must create a reasonable expectation in the offeree. The offerer must be willing to enter a contract immediately. No further negotiation should be necessary. Advertisements are generally considered invitations to deal only. They are typically not legally binding offers. An exception applies to highly specific advertisements. These must specify quantity and recipient precisely. They must leave absolutely nothing open for negotiation. This objective approach ensures commercial certainty. A common law offer must contain essential definite terms. These terms include the identity of the parties involved. They also require the subject matter of the contract. The price and the quantity must also be specified. Missing terms generally prevent contract formation under common law. This is true unless parties clearly intended to contract. A court might supply a missing term through custom or usage. UCC Article 2 governs contracts for the sale of goods. Under the UCC, an offer is valid if intent to contract exists. There must also be a reasonably certain basis for giving a remedy. The UCC allows terms like price or delivery time to be left open. Courts will supply reasonable gap fillers for these missing terms. Quantity, however, is generally required under the UCC. This requirement ensures certainty in the scope of the deal. Exceptions exist for requirements contracts. Quantity is measured by the buyer's actual needs in these cases. Output contracts measure quantity by the seller's actual production. An offer creates the power of acceptance in the offeree. This power can be terminated before acceptance occurs. Termination happens through revocation by the offerer. It also occurs through rejection by the offeree. Lapse of time or operation of law also terminates offers. Revocation is effective only when actually received by the offeree. Rejection, including a counteroffer, also terminates the original offer upon receipt. A counteroffer is a new offer relating to the same subject matter. It must propose different material terms than the original offer. Lapse occurs after the time specified in the offer. If no time is specified, lapse occurs after a reasonable time. Death or incapacity of either party terminates the offer automatically. This termination occurs even if the offeree is completely unaware of the event. Acceptance is a manifestation of assent to the offer terms. It must be made in the manner invited or required by the offer. Under common law, acceptance must precisely mirror the offer terms. This strict requirement is known as the mirror image rule. Any deviation constitutes both a rejection and a counteroffer. UCC Section 227 modifies this rule for the sale of goods. A definite expression of acceptance operates as acceptance. This is true even if it states additional or different terms. This expression must be sent within a reasonable time. If both parties are merchants, additional terms become part of the contract. This happens unless the terms materially alter the agreement. It also fails if the offeror limits acceptance strictly to its terms. Furthermore, it fails if the offerer objects within a reasonable time. Different terms often cancel each other out under the knockout rule. The mailbox rule, also called the dispatch rule, determines when acceptance is effective. This rule applies in distance contracts where parties are not communicating instantaneously. Acceptance is generally effective upon dispatch by the offeree. Dispatch means when the offeree sends the communication. The communication must be sent by an authorized or reasonable means. This rule applies only to acceptance communications. Offers, revocations, and rejections are effective only upon actual receipt. The rule protects the offeree who relies on the contract formation. Reliance begins once the offeree has sent their assent. If the offerer specifies that acceptance is effective only upon receipt, the mailbox rule is overwritten. The offeror is the master of the offer and can dictate the required method and timing. If an offeree sends a rejection and then sends an acceptance, the mailbox rule does not apply. The first communication received by the offeror controls the outcome entirely. If the rejection arrives first, the offer is terminated immediately. In this scenario, no contract is formed whatsoever. If the acceptance arrives first, a contract is formed upon receipt of that acceptance. Conversely, if the offeree sends an acceptance first, the mailbox rule applies immediately. A contract is formed upon dispatch of the acceptance communication. The subsequent rejection does not undo the already formed contract. However, the rejection may constitute a breach of contract. This occurs if the offeror relies on the rejection to their detriment. The timing of receipt versus dispatch is absolutely critical for determination formation. The mailbox rule does not apply to option contracts. An option contract is a separate promise to keep an offer open. This promise must be supported by independent consideration. Acceptance under an option contract is effective only upon receipt. This receipt requirement applies regardless of the transmission method used. The rule also does not apply if the offeree uses an unauthorized means of communication. A contract may still be formed upon receipt in this case. This requires the communication to arrive within the time an authorized means would have taken. Furthermore, the offerer can negate the mailbox rule entirely. If the offer specifies that acceptance must be received by a certain date, receipt is required. The offerer remains the master of the offer terms.